before this Court of Appeals, held in and for the State of New York, may now draw near, give their attendance, and they will be heard.
Mr. Tsimbinos.
May it please the Court, my name is Spiros Tsimbinos, the attorney for the appellant. It is the appellant's contention in this matter that the courts below misconstrued not only the spirit and intention of the statute in question, but its very language and also considerations of sound public policy. Although the New York City Administrative Code provision dealing with the pothole situation does provide in two specific sections that notice is supposed to be given to the Commissioner of Transportation. A separate subdivision in Subdivision 2 specifically provides an alternative method of providing notification, and that would be if there was written acknowledgement by the City of New York. In this particular situation, what we had was a pre-existing condition that was existing since 1971. The homeowner, Mrs. Dunbar, repeatedly called the city. The city came, inspected the premises, and then filed a report by the Parks Commission specifically listing on their notation that the sidewalk in question was cracked. The issue here is that written acknowledgement by the Park Department is sufficient notice, or must the notice be, as the appellate division ruled, notification by the Department of Transportation?
Well, form served quite a different purpose, in fact. It is not the Department of Parks and Recreation form that you're referring to as an acknowledgement of a defective.
The city is making the argument that the complaint was made on the basis of a tree pruning, and therefore the Parks Department's function was to prune trees, and they simply marked off the box. That really is not so. The record establishes from the EBT that was read into the record, the EBT of Mrs. Dunbar, the homeowner, that she called the Park Department not merely for pruning, but repeatedly because the flagstones were up. They had been that way for a number of years, and in fact the whole sidewalk in the entire area was cracked.
But that requires you to go beyond the report itself, does it not? And it's a question of what the function and the content of the report is in serving as a substitute for the usual notice.
My position, Judge, is that no matter whatever reason that the city employee or a city official visited those premises, once they're there and they see that there's a defective street condition, they're on notice.
But that's different from what the statute says that you're relying on
The
in terms of
statute
the
is a written
alternative notice.
acknowledgement by the city. It doesn't say that they have to have originally gone there for that particular purpose. Once they're there, and let's say they see that there's a tree pruning condition, but they also see that there's a cracked sidewalk, which was one of the complaints made by the homeowner, and they specifically mark it on their record, they have an obligation to then make it known to whatever appropriate agency of the city is required to correct that defect.
That's an enormous burden on the
No, Judge, if an ordinary person, an ordinary lay person is required to make written notice to the city, to the Transportation Commissioner, why shouldn't then the city's own employee make that notification? How much more difficult is it to send a copy to the Transportation Commissioner? The point raised by the city in this particular case, if we adopt the city's position and we adopt the position of the appellate division that it has to be only the Transportation Commissioner, we really come up with a bizarre type of a situation. What happens if Mrs. Dunbar had called Mayor Koch instead of calling the Park Department, and he had gone down with a crew full of photographers, and he had said, yes, Mrs. Dunbar, the street is cracked, and the next day he sends her a written letter saying that the street was cracked, we're going to take immediate action. Okay? The city would be arguing today that that's not sufficient because that acknowledgement came from the mayor and it did not come from the Transportation Commissioner.
Let's assume that you're absolutely right that the acknowledgement does not have to come from the Transportation Commissioner, and that a written acknowledgement by any department is sufficient, and that it doesn't require a written complaint. Let's assume all of those things. Should not at least the written acknowledgement upon which you rely in lieu of all of these other things refer specifically to a dangerous defect?
Yes, Judge, and
where does
it does in this case.
so?
Well, in the form where it says sidewalk condition, it's marked cracked. The city, the inspector himself wrote down the word cracked. I don't-
Is that sufficient when the real purpose of the report of the Parks Department, as I understand it, is only to do work on in pruning trees, and this was an incidental notation saying cracked. Is that the equivalent of acknowledgement of some dangerous defect, a complaint?
Yes, Judge, I would say that that would be sufficient, but in addition, in this particular case, the initial report was not only for the true pruning, the party specifically complained about the cracking of the sidewalk. Therefore, her complaint, when they came down, it was to cover both situations.
But the initial report was oral. wasn't it?
Her initial complaint was over the telephone.
Yes,
Okay.
so that's really irrelevant. You have to rely on, if anything, you must rely on the written acknowledgement.
All right,
And so we have to look at the written acknowledgement.
My
and see
position
if
is-
that's sufficient to
My
satisfy.
position is that it is sufficient, at least for the notification requirement. It's sufficient to meet that. When you get into other issues as to the city's liability, that would have been a question of fact for the jury. But I think the notice requirement is specifically met by that situation.
Mr. Tsimbinos, then you're asking us to add a category to the statute, are you not? Because as I read the statute, the notice is to unsafe, dangerous, or obstructed. You're now saying, or cracked, which is different from those
No,
three.
Judge, I'm saying a cracked sidewalk is a per se dangerous or defective
Per
condition.
se?
Yes. A cracked sidewalk, after someone fell down and injured himself, what would be different than a notification if it had been made to the Transportation Commission? What would a person supposed to let the Transportation Commission know? There is a cracked sidewalk in front of this particular situation. I think that would be the same type of notification that
You
would
wouldn't
have.
recognize any circumstance in which the word cracked could mean that it was not unsafe or dangerous or obstructed. You couldn't have a crack in a sidewalk which was none of those three?
I think you're then almost putting an additional impossible burden on even the written notification requirement. An ordinary lay citizen sees a crack.
No, we're talking about the acknowledgement, which is taking the place of the usual notice of claim requirement
Right,
in the outbursts, and what you're doing is adding a category in terms of what we should read into that.
No, but I
notice.
think what Your Honor may be attempting to do is to provide a larger burden on an acknowledgement than the original notification. It just has to be, there has
The
to
only
be...
thing I'm trying to do is to get to the bottom of this.
Well, I think the designation that it's a cracked sidewalk is sufficient to put the city on notice, especially when they physically went and inspected it, okay? And I think that's enough to comply with the acknowledgement, okay? Otherwise, I think you're putting an impossible burden.
If anything, this was a motion to dismiss after oral argument, wasn't it?
The motion was dismissed after the opening case.
And therefore, if anything, that may have been premature. It should have, we should have allowed you to take some testimony.
That's my second point in my brief, Judge, that it happened without even giving the plaintiff an opportunity to proceed further. And I've cited numerous cases where the courts generally frown on that in terms of denying an opportunity to go further.
But what could the plaintiff have added? Since we're only talking, as I understand it, about the adequacy of the written acknowledgement.
Well, there may have been an issue if the case had gone further, that perhaps additional records might have come up, that either the Park Department did notify the Transportation Commissioner, or someone from the Park Department themselves might have been able to acknowledge more of what they saw and what they put into the report. I have to have some conjecture at this point, since I wasn't the original trial attorney and since the matter did not proceed further. But those are possible avenues that could have been explored.
But even so, in the latter event, you'd need a written acknowledgement, and even if they had seen more, the only writing we have says cracked, just a single word.
But it could have gone into a further explanation. Again, my position is that the cracked designation is sufficient, but it would have been allowed an opportunity to go further into the actual condition. I also would like to stress that this court has repeatedly said that the purposes of the written notification requirement is not to save the city money and not to beat somebody out of a lawsuit, but to be able to give notification to the city so that they can correct the defective condition. Here, the city clearly had notification, and they were under an obligation to take steps. Otherwise, we're going to have a situation where we're really, as a matter of public policy, encouraging laxity. You're saying that one city agency has no duty or obligation to inform another city agency. The left hand doesn't have to know what the right hand is doing. And I think that's a terrible public policy situation, and it's only going to foster greater negligence in our particular situation. I think the Blake case that I've cited is an important precedent by this particular court on the issue that once an inspection is made, that is deemed to give the city notification. The other issue that I'd like to point out that I think is very important, in the appellate division, and the city has also argued that in reading the legislative history of the November 15 City Council proceedings, they cite two amendments that were discussed, and they claim that since those two amendments were not voted, that is an indication that the intention of the city council was not to go along with this written acknowledgement situation. If we take a look at the actual city council minutes, the first amendment that is cited that had to do with a requirement that other city agencies who had field inspections, like the police department and the sanitation department, would be affirmatively required to make reports if there were defective sidewalks. That is different in this particular situation. The reason that amendment was voted down was a feeling by the city council that would then take away from the police duties, other duties that they would have. In fact, if you look at those pages, there's discussion by the members that they did not want to take the police away from their police duties to conduct pothole inspections. Also very significantly, and I think that amendment almost acts in my favor, that amendment, which it would have greatly enlarged the situation that I'm arguing that occurred in this case, was voted down by a vote of 18 to 17. In other words, it failed by one vote. Okay, so that is a clear expression that the city council was largely in favor, okay, of the position that I'm advocating. In fact, they would have gone far beyond but for one particular vote. The second amendment that is discussed, the amendment that had to do with also allowing notification to be given to the controller's office or to the borough president's office, again, I think the appellate division was totally misled by relying on that amendment, because that amendment had 3 or 4 sections to it, including a section that would have provided that the written notification requirement would have been dispensed with if the condition existed for more than 6 months. So when the city council was voting as a package, they were voting on all of those changes. And
Thank you very much.
To simply pull one out is not fair.
May it please the court, I'm Ingeborg Garfield, appearing for the city.
Mr. Garfield, we have here a statute which is in derogation of the common law.
And should be
And so it
strictly
should be
construed.
strictly construed, right?
Yes,
And it was
Your
drawn by the city
Yes,
to
Your Honor.
protect the city from liability.
Not only that, Mr. Chief Judge, but also to give better service, to be able for the city, with all the many streets that we do have, we need not have police office and sanitation, as plaintiff's counsel here argues, to find the pothole laws. We are not in that lucky position.
True enough. So you say very clearly three different things. Unless that written notice of the defective condition is given to the Commissioner of the Department of Transportation,
Right.
or any person or departmental and so on,
Right.
or where there was previous injury
Not a
and
case
written notice
relevant
thereof
here.
was given to the city agency,
Right.
or there was written acknowledgement from the city
Right.
of the defective
And
condition.
it's clear we need not go into the first two, although plaintiff sometimes uses them interchangeably, but it's clear from his brief that he's trying to bring this case under the third alternative, written acknowledgement from the city of the defective condition. Now, the court will notice that the legislature, the city council, did distinguish between city and city agency, because in the second alternative, that is the only time the legislature has used the term city agency to say if there's a previous injury. Why? Because a notice of claim will be filed to the controller, who then makes sure that the proper city agency gets notice. There is not that problem. Otherwise, the statute, read as a whole, uses city and Department of Transportation or Commission of Transportation interchangeably. When the statute says there must be actual written notice to the Commissioner of Transportation. Now, under the statute, the Commissioner of Transportation must keep the records of the notices, and then the statute says received by the city. But we just learned that written notice of the defective condition must be given to the Commissioner of Transportation. The first indication that city and Commissioner of Transportation is being used here synonymously. It also says that the Commissioner of Transportation must keep the acknowledgement the city gives. Yet under subsection 4, the statute specifically states acknowledgements must come from the Commissioner of Transportation. That's the first indication. Looking to the language of the statute, reading it as a whole, not giving it a strained interpretation, it's clear that city and Commissioner of Transportation are synonymous.
Why couldn't it mean as well that within the city, whatever agency receives the notice is to transmit it to the Department of Transportation?
I think there is also in our brief at page 13, there's an earlier draft of the pothole law which did not have the acknowledgement provision. In fact, the acknowledgement provision of the pothole law of New York City is rather unique. Many other such statutes don't have that. And in that provision, it shows how the City Council used it interchangeably, because there it says written notice must be given to the city by certified mail to the Commissioner of Transportation. Another indication why it could only be to the Department of Transportation and not, for instance, the Parks Department, like in this case, because it is only the Department of Transportation that by law maintains and repairs the public roads, streets, and sidewalks.
How about that portion that says defective condition that caused an accident?
I'm sorry?
That's another method, isn't it? If an accident was caused by a defective condition, is another method of giving notice to the city, correct?
There are only 3 ways to give notice to the city, the ones that we discussed. Now, at
And why isn't the third one separate and apart where it says by a written acknowledgement from the city of the existing condition?
It says or
Or,
there was written acknowledgement. I think it treats them as 3 alternatives, written acknowledgement. Now, written acknowledgement here from the city, from the Parks Department, this form that has been used by a plaintiff to say this constitutes the written acknowledgement, Judge Kaye, you had asked, first of all, the purpose of noting the cracked sidewalk is since the homeowner is responsible by law for the sidewalk in front of his personal property. When Mrs. Dunbar called up and said, please prune the tree, if there is anything that the Parks Department does and would damage the sidewalk, the homeowner would come back to the city and said, now you have damaged my sidewalk, since I'm responsible, but you did it, you repair it. Therefore, when a Parks Department inspector goes out to inspect, he makes sure that he notes on the form, for purposes of protecting really the Parks Department, what's the condition of the sidewalk at that point. Whether or not cracked would in fact constitute such a dangerous and hazardous condition under the law is another question. Judge Bellicosa asked that. In fact, I did ask the Department of Transportation that very question, and I was told that a cracked sidewalk is not necessarily a defective condition under the statute, because what if it's a hairline crack? It wouldn't be a perfect sidewalk, but it would be a sidewalk where one would hardly assume serious injury would result. The City Council minutes to which plaintiff has referred really do not support his argument at all, because the City Council meetings, a copy of which was provided for the court in 137 pages, make clear that the City Council did not like the law a bit. It was not in favor of the prior written notice law, but it passed it. And it rejected not once, but twice, the very argument that is urged before this court, and that is the intra-agency duty. We are not dealing here with a city government of half a dozen people where, according to plaintiff, laxity would result, because logically the left hand should know what the right hand is doing. There's about 200,000 city employees. What would the purpose of the law, which is to quickly report these defects to the proper authority, to one authority, not to the Human Rights Commission. What is the Human Rights Commission going to do with a report of a cracked sidewalk in Queens? They may be sitting on it until it gets through the bureaucratic mess to the proper authority, to the inspector, who
So
then
why
goes...
don't they make it more explicit? They drew the regulation, they drew the ordinance. Why don't they make it explicit instead of saying to the city, or from the city, excuse me?
They said actual written notice to the Commission of Transportation, written acknowledgement...
I'm talking about the subdivision that you and I both agree is the controlling one here.
Yes,
It says, from the city.
yes, but the city and the Department of Transportation, which Judge Walkley is the only one who deals with defective sidewalks. They are the only ones who repair it under the statute. Why give it to the Parks Department? It doesn't say written acknowledgement shall be given from the Parks Department, if in fact the argument that council makes is...
But it doesn't say written acknowledgement from
Shall be given by the Department of
the
Transportation.
Transportation Commission. It doesn't say that. It says
By
from
the Department
city.
of Transportation.
No, number 3.
Yes, but, and now I'm referring to subsection 4.
You don't talk about
Okay,
subsections.
yes. Which supports my argument. It says, written notices which the city receives,
The city receives. It doesn't say
right?
from the Transportation Commissioner, it says the city receives.
That's correct, but it says in subsection 3, written notices which the city receives, yet initially, the first alternative, it says that actual written notice must be given to the Commission of Transportation.
Or-
So who else? But that's,
But
yeah,
then there's an or, and then it goes to,
that's previous injury. Judge Titone, that is not the case, and I think I tried initially to say why the city council here has distinguished between city and city agency. That is the only time it said a city agency, because once there's a previous injury arising out of the same defect,
If the written notice is to be given to the Commissioner of Transportation as one of the methods of notifying the city of the defect,
right?
what logic is there then to simply requiring a written acknowledgement from the city
Well, that
as
is,
a substitute method of giving notice? If they were going to require it from the Commissioner of Transportation, there's no need for the acknowledgement
well,
if you have notice to, if the notice is given to them in the first instance, is it?
right, but the statute does require written acknowledgement. Why does it require?
From the city, it doesn't say from the Commissioner of Transportation.
Well, it says under subsection 3 from the city, but then it has a special subsection, Judge Hancock. Subsection 4, which says, written acknowledgement shall be given by the Department of Transportation of all notices received by it. Why? It is a rather large agency. We want to make sure that the city has in fact received actual notice. What is the purpose of the statute? The purpose of the statute is to ensure that the city did in fact receive a paper where it said, please go out to 25 Fifth Avenue, there is a big pothole out there. And once we receive that, once the Department of Transportation receives that notice, it gives it a stamp, it gets a number, and the...
Let me see if I can explain rationally why this thing could fit into an interesting pattern. The city says, look, if you see that there's something wrong in the city, you've got to serve notice, and the notice has to be served on the Commissioner of Transportation. On the other hand, if there was a previous injury to the person as a result of something that was defective, and a notice of that injury was given to a city agency, then that'll be notice enough, because someone was actually injured. You're not talking about just seeing something. Or they say, but if the city writes to you, then certainly the city knows about it, and that, as far as we're concerned, is sufficient notice. Why isn't that a very logical explanation of why it's parsed out this way? And if that's a logical or reasonable explanation, then why isn't that all that we have to inquire into, rather than saying it's not really what they meant? Because again, and we agreed initially in derogation of common law, strictly construed, and you wrote it.
Because if the court were to adopt the plaintiff's argument that the Parks Department's report, which was made because somebody asked, prune my tree, if a report by any of the many city agents that we have, which are generated for purposes that are irrelevant to the pothole law, then what you're saying, Judge Wachler, is that now, let's take the Parks Department form where it says sidewalk condition cracked. It's made, as Judge Kay said, for a very different purpose. All of a sudden, we are now accepting the plaintiff's argument.
By the way, these
That
are
constitutes-
just questions, they're not
that
positions.
that constitutes notice to the Commission of Transportation. Judge Wachler, what you would say now, what does the Parks Department do with that? Well, it goes out, it prunes the tree, and it files this little notice in its file. The Commission of Transportation, what's the purpose of the law? Did he ever receive notice? In any way, shape, or form. He did not receive notice, and he did not have an opportunity to go out, inspect, and repair the defect. That is such an absurd result that is argued before the court. The legislator couldn't have intended that.
Why doesn't the statute, by providing these two alternate categories, put the burden on the city in those instances, so that within the city, the agency or person who's actually received the notice will then notify the Department of Transportation?
Are you talking again about an interagency duty? From a different...
The city and all of its many parts, yes.
Yes, well, again, I would have to refer you to the rather lengthy debate in the City Council on that particular issue. Why shouldn't a sanitation department worker who goes with his truck down, they have discussed that. They felt that it was too burdensome to do so. Because, Judge Kay, what also would happen, the cop is on the beat. Now, where do we stop? At this point, it's urged that he should also report sidewalk defects which do not come within the jurisdiction of the police department. The building department is going to be the next one. He says, listen, cop, when you go into the building to arrest somebody, I want you to report really hazardous conditions. The sprinkler system isn't working. There's a fire on the 3rd floor. They don't have the guards for the children. Where is it going to stop, Judge?
But you have got a point where it doesn't stop when you say if somebody falls on this defect,
Right.
it has to be repaired within 15 days. And if it's not, then the city's liable,
Correct.
even though the commissioner doesn't know about it.
That's not correct.
If the commissioner were not told about it, but a person was injured,
A person was injured, the city would know because with the
within the 15 days I'm talking about.
The city has taken, that is why it gives half to the public. It's not just a protection of the city treasurer, Judge Titone. The city says if there's a prior injury and the notice of claim need only be filed, as we know, within 19
The
days.
notice of claim only has to come in within 90 days.
Within 90 days.
And within 15 days if the person...
But Judge Titone, that's the city's problem. The city will say we're liable
This
for
may
it.
be the city's problem too, right?
No, in this case, the plaintiff has not proven this case.
Okay, at any rate, it's now our problem.
Yes.
Thank you very much. Matter of Black versus Metropolitan Tobacco Company. See this note? Freeland, isn't a point reached where we feel that deferring to the judgment of the agency might lead us to a very absurd result? And is this not one of those cases?
No, Your Honor, it is not. If anything is absurd here, it's the legitimate decision rule of Millar, which the appellate division majority followed below. The Snyder decision of this court established that a firing can be a compensable cause of disabling emotional stress. And once that's been established, the question becomes, in any particular case, whether the circumstances surrounding the firing, plus the physical and mental makeup of the stricken worker, combined to show that there was legally sufficient excessive or undue emotional stress coming out of that incident. That's what happened in this case. You have an extraordinary situation. A man who had been hired at age 60 to be a salesman, had all the perks and all the responsibilities of a full-time, permanent sales staff member, gets a raise, and 3 days later, without warning, without preparation, he's summarily fired.
Assuming that there was all the reason in the world to fire him, but nevertheless he feels subjectively the enormous shock and trauma which comes to anyone who's fired. Any difference in the...
There may very well be a difference, just as there's any difference when the board looks at a case involving what this court has called, or what has been called ordinary business pressure, like Gates. That doesn't mean, in Gates, the man had a heart attack after being irritated over a canceled order. That doesn't mean that every time someone has a canceled order or irritation coming with that and then has a nervous breakdown, that's going to be a compensable claim. The legislator created the board to look at these cases on their facts. The key thing is not so much the trauma, although I'm not conceding that firing always causes this trauma. I can think of several situations where firing could actually be liberating, but the critical thing is the circumstances. What were the circumstances surrounding the firing? That is where Millar and the lower court are wrong, to cordon off an entire range of clearly work-related incidents and say, as a matter of law, the board can only look at, was this a reasonable employer action, since was this within the scope of what an employer can do with regard to personnel?
Let's take this position, this hypothetical, and see what you would say. Let's assume that a manufacturing company is shut down, and 300 people who have worked there for years suddenly are without work. And this is traumatic, of course, and emotionally upsetting. And 3 of them who have had heart conditions suffer heart attacks as a result of this announcement, which comes suddenly. Are those compensable injuries?
Well, I'm loath to put the board in a position of saying this is what we would do before a case like that has reached the board, but what I would say is, once again, you look to the individual circumstances.
How would that supposed case differ from this one?
All right. In a word, the raise. Man gets a raise. A raise means, thank you, keep on the job. You've done a wonderful job. We expect you to continue. We'd like you to continue. 3 days later, complete turnabout. Rug pulled right out from under him. No warning. That's not in your hypothetical. But that, I think, almost on its face, would be a source of undue emotional trauma.
As I see this, there's absolutely no question on causal connection.
No, not at all.
There's no question on arising out of. The question is accident.
And
That's the hang-up. And
Yes.
that's what Millar turns on.
Yes, that's quite true.
Now, how, if this is an accident, why isn't almost any upsetting occurrence which happens, any frustration which may happen during the course of employment, an accident, if it leads to a cardiac arrest of some kind or some sort of a heart attack?
Because it isn't. It isn't in this case, and it hasn't been in any of these objections, which, by the way, were expressed below, were raised all the way back to Climas, when they said, my God, you're going to allow people who suffered some sort of emotional stress at work, or then in Wolf, people who have suffered psychiatric injury. This is too intangible. Everyone has stress. Everyone is subject to these things. The only difference between what has gone on since Climas, since Schneider, and since Wolf is the type of stressful event, which in this case is an employer personnel action. What you have raised, Judge Hancock, can be said of all the routine or seemingly routine stresses that workers are subjected to during the performance of their work, which have led to nervous breakdowns, heart attacks, strokes, and the like, which have been claimed, some of which have been allowed, some of which have been disallowed. The board has the expertise to look at these claims and say, this falls into the category of something that does not rise to the level of an accident. It's something that everyone in this situation suffered. Under the facts of this case, this is something that that is not distinct enough or unique enough or extraordinary enough to be an accident on these facts, and others in which it says, yes, there was something there that Rose...
I don't want to, this is my last question,
Yes.
but I'm troubled with this. How do you articulate the difference?
All right. This was actually done several years ago by both the board and the court below in a case called Laing versus Burroughs. It's cited at page 21 in the footnote, in which a worker suffered, it was a claimant's appeal, and the court denied leave in it. The worker was switched from a job that had her dealing with numbers to one that had her dealing with people, and she couldn't handle it and suffered a nervous breakdown. Now, neither the board disallowed the claim and the court upheld them, but neither of them referred to Millar, neither of them talked about, oh, that was just from a personnel action that was reasonable, that's the end of the case. They looked at the facts, they looked at how many people were affected, they looked at the pace of the transition, they looked at all the individual factors. The court even said, it's up to the board, citing Klimas and Wolf, to look at the peculiar circumstances of each case. And they found that it was simply merged in all the routine problems and stresses that workers normally encounter. Now, this standard, when not used to cordon off an entire category of disabling events, but simply applied to see whether in the particular circumstances of the case there was something unique or not unique, something unduly stressful.
If we reverse here, I imagine it would be prudent then for any employer before he or she undertakes to fire someone who have that person take a physical.
Well, that would be up to the employers, but I
So
understand...
there's good news and bad news. The good news is you're in excellent physical condition. The bad
The
news
news is you're out. I understand that. I think that what you're saying is that this will somehow condition or inhibit employers from exercising their natural prerogative, their prerogative under law to hire, fire, and the like. My answer to that is that prerogative is already hedged by numbers of regulations, statutes, common law. I would say that this would no more act to inhibit the employer than, say, a law forbidding race or age discrimination would make an employer think, well, I can't fire this unqualified member of a minority group because then it's going to automatically be discrimination. That's...
Thank you very much.
Hmm?
Thank you very much.
I reserve whatever time remains for rebuttal.
Mr. Manning, why shouldn't we do as we've done in most of these cases and defer to the agency?
Because it is our contention that this is not a question of fact. This is not one of the substantial evidence questions that comes before the third department in this court. This involves a question of law. We believe that question of law is whether cardiac events or incidents related to discussing conditions of employment should be deemed compensable accidents.
Well, will you say then that you would want a rule of law which says that under no circumstances can an agency find a correlation between a discharge and a heart incident or some other disability?
Certainly not, but we believe the circumstances and facts of this case would clearly reflect that when there is nothing more than discussing conditions of employment, then resulting incidents should not be deemed compensable. That in and of itself, we would ask this court to hold.
But as soon as you relate it to the facts and circumstances of this case, doesn't that bring you right back to the deferral to the administrative agency, particularly one like the Workers' Compensation Board? Because the difference here, as I heard your adversary, is that there is something different. There is surprise or some kind of a finesse in terms of the actions that were engaged in. Doesn't that make it different and sufficiently within the province of the fact finder here, the administrative agency?
In this case, we do not believe that it does. In fact, given the circumstances of this case, as the Attorney General has argued, are raised one day and several days later being advised of loss of employment, we believe that supports our position even further. Bear in mind that this man was given a raise on January 1, 1979. On January 4, 1979, he was told not the very next day, but as of March 1st, his full-time job was to be eliminated. There was going to be a meeting the very next day to discuss the possibility of being provided with part-time employment and to see if he could be eligible for Social Security benefits. We're all told of surprise in this case. However, we must bear in mind that Mr. Black had previously been retired from another job. There's been no argument that he was promised a job forever. That is a risk all face in the private employment sector. Nobody is guaranteed a job for life. Mr. Black realized that.
But
Now,
now you're getting, it seems to me in your argument, you're getting to the issue of causation.
I am conceding, I have to concede that there's substantial evidence that this event caused his heart attack. There's no dispute about that. However, each law does not address every individual circumstance. The compensation law, as this court has held in Climas, has noted when there is undue stress and strain, the resulting incidents can be deemed compensable. However, this court has also noted in Weinstein versus Apex and many other cases that there are stresses and strains we all face in everyday life. Resulting incidents therefrom shall not be deemed compensable. I received a reply brief from the Attorney General's office which contends that our reliance upon Weinstein is misplaced, and furthermore, that this court's decision in McCormick versus Green Bus Lines eliminates the Weinstein rationale. McCormick versus Green Bus Lines dealt with a question of physical exertion. This is not a physical exertion case. Miller...
What about Wolf? Wolf was not a physical exertion case at all, and yet that was held to be compensable.
Certainly. I would be hard-pressed to deny that Ms. Wolf was not faced with undue stress and strain when the man she had been this man's right-hand man when immediately prior that this man committed suicide, and prior to doing that, he alerted this woman to go call the police. She opened the door and saw what remained of her boss. We think that is certainly an undue stress and strain of employment, whereas loss of employment is not. In Millar, the court noted the difference between everyday stresses and strains, that every employee has these worries, these concerns about getting a promotion, not getting a promotion, even loss of employment. The Third Department in Millar referred to this court's decision in McCormick, and it also referred to a decision which at that time had not been affirmed, that being Strauss versus Des Moines Freehite. That case also relied upon the Weinstein rationale, and that case had also been affirmed by this court some 3 years subsequent to the McCormick case. Now, the Attorney General has made reference to the Laing versus Burroughs decision, and we believe that decision proves our point. That being that there are certain circumstances, certain stresses in life, in employment life, that resulting injuries or incidents should not be deemed compensable. The claimant in Laing was faced with a change in the office. The board correctly followed the rule of law that stress was not an undue stress. Summarily, in a case of Alvers versus Hamilton, Fulton, and Montgomery County BOCES, a teacher was transferred from job to job inasmuch as he was not doing a good job. He alleged a cause-related psychoses. Again, the board followed the rule of law that those stresses we all face.
Manning, when you speak in this area, it's very difficult to try to find rules of law. They're very evasive. Each case seems to be, for instance, this case, if Mr. Black's secretary saw him slumped over the wheel of the car dead, she might have been able to recover some compensable injury, as a result of the trauma of seeing him dead, whereas his family could not.
That's quite possible,
Seems
Your Honor.
anomalous.
We believe it's different circumstances, different stresses. As I indicated, the one stress is a stress that all face in employment life, a possibility of job loss. The other stress, which one should not be expected to follow or to encounter in their job life, that being seeing your boss commit suicide, see somebody drop dead before you. We believe that's certainly different. Now, the Attorney General would also argue that this court's decisions in Climas and in Snyder were firing cases.
How do you distinguish Snyder?
Snyder, we distinguished by the fact that it was not a simple firing case. It was not a case involving discussing conditions of employment. The facts of that case and the facts of Climas readily reflect that the employer acted in what could only be termed as harassment. The facts in that case reflect that Snyder's employer advised him he was incompetent. He would see that he would get him out of the department. The man was stripped of his job functions, placed on a desk and a phone, and given no work to do. That could not be termed simply discussing conditions of employment. The facts of this case, we believe, are readily reflected was nothing more than discussing conditions of employment.
But you
see
draw
the
the line...
I'm
Excuse
sorry.
me. Go ahead, Chief.
You see, the converse can be just as traumatic. You say to a man, everything is wonderful, it's great, we're going to give you a raise, you're happy, you're employed, assume, hypothetically, you're employed for life, you never have to worry about a thing. The next day you're fired. I mean, that's almost worse than constant harassment. I mean, that's sheer shock
As
and
you-
trauma.
In that hypothetical, you indicated that the person was advised he was given a job for life. There's nothing in the record to
So if we
reflect
took
Mr.
out
Black.
that one factor, we'd have the same case we have here.
Yes, and we believe that's a very, very important fact. We would respectfully request that this court continue to follow the natural evolution of the law in regard to stress cases. That being in recognizing the inherent difference between stress created by the demands of employment and stresses created by discussing conditions of employment. It is for those reasons we would respectfully request that this court affirm the appellate division decision in its entirety. Thank you.
Thank you very much.
If I may, Your Honor, just 2 points. The first is that the court in Snyder made it very, very clear that the emotional trauma could be based simply on the 2 episodes, one in which the chairman of the commission said, I don't want you here anymore, the rumors are true, and the other being when he actually fired him and said, you're out by a certain date. The second is, naturally, we're not turning the compensation law into a backdoor to a lifetime guarantee of lifetime employment. But the critical thing is here, bringing up Wolf, is it's not necessary for the employer to say, oh, you've got a job for life, which I don't think any employer would really expect, but the employer's actions creating a belief, an attitude on the part of the employee that predisposes that employee to the emotional trauma, just as Ms. Wolf's employment worked to create an attitude that made herself think she was indispensable, and then created an emotional state that led her to tremendous depression when she felt that she was responsible for not preventing her boss's death. Thank you, Your
very
Honor.
much. Matter of Reed versus Federal Insurance Company. Seems to me, Mr. Holloway, that seems to me that the insurance company might have made a tactical error here when they paid the $211,000 after paying off the mortgage.
With the benefit of hindsight, that could be true. I'll address that issue, although that is the second issue in the case. What really happened was this. As of the time that these events transpired, there were significant unpaid taxes on the property. It was pretty clear that if the companies did not step in and continue with the foreclosure sale, there would be a tax sale as a result of which the properties were going to be lost as to the insureds and as to the company. So that by doing what it did, the companies in effect maintained the property. It still is available. It maintained it during the period that this litigation was going to ensue in order to determine whether or not there was any obligation to pay these insureds. And frankly, the result in the appellate division seems to us to be illogical and inequitable. What they did in effect was to say, we're going to deprive you of the right of the set-off as to the amount paid to the mortgagee because you proceeded with the foreclosure sale. However, the fact is that there is no relationship between the amount paid to a mortgagee and the value of the property. The property itself, if it had a value greater than the amount paid to the mortgagee and the company were entitled to keep it, would result in a windfall to the company. Or in this case, if the value was less, it results in a windfall to the insured. We submit that the logical and the reasonable way to resolve the issue if the court gets to this question, is a reconveyance of the property, plus whatever damages may have been sustained through loss of use, or an award of whatever the value of the property is. This would put the parties back in the relationship which they should have been in the event it's determined that the companies do owe money to the insured. Now, in a nutshell, that's our position with respect to the set-off issue. With respect to the other question on the appeal, our position is that on the facts of this case, the court should recognize that an insured person who is simply acting as a straw man or as a conduit to funnel the insurance proceeds to the person who committed the arson and destroyed the property should not be entitled to recover.
Was that issue preserved?
Yes.
I'd see that there was definitely an issue with respect to her innocence and her complicity or lack thereof.
Yes.
And alleged fraud on her part. But what about this
Okay,
straw person
Sure.
argument?
After the court charged the jury and indicated the kinds of questions that were to be submitted, there were lengthy discussions in chambers. It's in the record between pages 883 and 894. And in those discussions, in at least two places, the counsel for the companies mentioned that there existed this unity of interest between the daughter, Cheryl Ann, and the father, Russell. He also objected to the fact that the way the issue was submitted to the jury, requiring a finding of knowledge and consent on the part of Cheryl Ann, was in error. In addition to that, it's very clear that the jury completely understood what the questions really were. They asked this, which is a very, very pointed, precise question. May we regard Russell Reed and Cheryl Ann Reed as one person, as suggested by Mr. O'Connor in his summation, or must we regard them as completely separate individuals operating independently? And unfortunately, rather than responding, as we say the court should have, by saying, yes, indeed, you may recognize the unity of interest, the court simply reread, and it covers about 10 pages in the transcript, reread the part of the charge already given concerning incendiarism, circumstantial evidence in that regard, and the charge regarding the fact that under these circumstances, the mere fact that this is a daughter does not bar her recovery because of the father's arson. We submit that that was error, that the court should have responded directly to that inquiry by the jury.
Was there any exception to the court's answer?
Yes, there was. The exception appears at page 907 in the record. As a matter of fact, at that juncture, I believe the court itself said to our counsel that you have an exception.
Page 907 of the appendix.
May I double check that? Okay. I'm sorry, the reference is at page 911 of the record at the bottom. Mr. Wegg said, Judge, as previously stated off the record, may we have deemed, we would deem our exceptions as repeated and reinstated as they were at the conclusion of the court. Yes, they may be deemed made. Mr. Wegg, prior charge. On the following page, Mr. O'Connor, this is toward the bottom of page 912. I would renew my exceptions and requests made earlier, and continued with an exception as to another matter. In any event,
And which particular exception do you say was brought forward?
I believe that in the context in which this occurred, it's clear that the court was granting exceptions to counsel which had previously been taken during the colloquy, which is in the record, following the court's charge to the jury.
Yes, but you say a specific objection was lodged to the matter that's being discussed at this very point.
And I believe that is at page 911. May I refer to it again, please? Yes, at page 911, which is a statement by counsel for the plaintiff. The "we," I think, refers to the fact that both counsel would have exceptions as repeated and restated. And in any event, at page 9...
Which was the original exception taken? Now, this refers back to a prior exception.
That is correct.
Where was the prior exception?
Okay, that would be contained in the record following the court's charge, which is from page...
At 886.
Yes, sir, I believe it begins at page 883 with Mr. O'Connor's statement toward the bottom of that page. The discussions continue over to and including page 894. On the latter page, Mr. O'Connor says, "I would request that the jury be instructed that based upon the evidence adduced during this trial that as a matter of law, Russell Reed caused, procured, or solicited this loss, it would be an absolute bar to recovery by both plaintiffs in view of the unity of interest that exists between Cheryl Ann and Russell Reed. The court, I deny to charge that."
Where do you see that? 894?
I was reading, sir, from page 894 toward the upper part of the page.
But then the court goes on to say that's for the jury to decide.
That's correct.
That issue was put to the jury.
That is correct.
And then the jury rejected that.
Well, the problem is that the way the case was submitted to the jury, as far as Cheryl Ann is concerned, was that there must be some evidence of her knowledge and consent to the arson in order to prevent her recovery. There was not a submission of the issue to the jury as to whether she was united in interest with her father, whether she was a straw man, or whatever you wish to call her. That was not submitted to the jury. And if I may say, this all became very much sharpened when the jury itself asked the question. And at that point, I would submit that the court should have responded that indeed you may regard Russell Reed and Cheryl Ann as one person. And indeed, you must not regard them, you don't have to regard them as completely separate individuals operating independently. As I understand the rule, the purpose of the exceptions to the charge and request is simply to bring to the attention of the trial court the position of the party. And I submit that that was really done here, and that it's very clear that the trial court knew what our position was. I believe that the problem with respect to the analysis of this case by the appellate division and by the lower court is their reliance upon the line of cases dealing with the so-called innocent co-insured. The appellate division opinion talked about how there were two lines of cases, one permitting recovery, one denying recovery, where there were two insureds, one of whom committed an arson or a fraud, and the other of whom was innocent. We say this is not a case involving an innocent co-insured. The questions involved in that type of case are completely different from the questions involved in this case for a number of reasons. In the first place, most of the innocent co-insured cases involve a husband and wife and a tenancy by the entirety. You know, it's a relationship which is created for a bona fide purpose. It's maintained for a bona fide purpose. The insurance coverage is obtained in both names for a bona fide purpose. In this case, the creation of the interest of Cheryl Ann in the property was hardly for a bona fide purpose. the conveyance to her was of property, the title to which was totally unmarketable. The proof in the record by Attorney Wolf is that there were something like $150,000 of outstanding liens. Excuse me.
This was, you couldn't show this was a fraudulent conveyance, did you?
I believe it was a fraudulent conveyance,
Yeah,
but
did you have a right to attack that? You
no,
weren't a creditor.
no, we do not take that position. We only suggest that that is one of the elements which goes to the question of whether Charlene was a bona fide owner of the property or whether this was simply a scheme.
But could you attack that?
I don't
Only a
think we could.
creditor could, right?
The creditors could, we do not take.
And the bank, they went ahead and paid off the mortgage, didn't they?
Well, we paid off the mortgage.
Yeah, but the bank did really.
Yeah. But to answer your specific question, we have not taken the position that we could attack directly the conveyance as a fraudulent conveyance. The point being, however, that in conjunction with all the other facts in the case